their given tendencies shall be heard. Now say the Commonwealth of Massachusetts goes open. Please be seated.
Good morning, everybody. Welcome to the Appeals Court. I am Judge Rubin. I am lucky, and you are lucky, because I'm joined today by two outstanding colleagues. To my right, Judge Neyman. To my left, Judge Walsh. We will be hearing 5 cases this morning. And the rules of oral argument, for those of you who aren't familiar with them, are pretty much always the same here. It's 15 minutes per side, and there is no rebuttal. We've read your briefs with some care, so my general recommendation is that you get right to your arguments, although, of course, it's your time, and you may do with it as you wish. And with that, why don't we call the first case? It is number 22-820, Commonwealth versus Guerrero, and we will be hearing first from Ms. Sullivan-Puccini.
Good morning. May it please the court, Sharon Sullivan-Puccini on behalf of the defendant.
Can you move the mic a little closer to your mouth?
Okay.
Thank you.
I'll talk louder.
Please speak up a little bit.
I'll talk louder.
Thank you.
Okay, I'll get right to it. For the first issue on the reasonable suspicion. And I want to just point, I did not write the brief. It's a colleague of mine wrote the brief, and she's left the panel, so I'm arguing on her behalf. And so what I thought I wanted to start with today was to say, when I read the brief, the first thing that came into my mind, and maybe it came into yours, was why didn't the officer get a search warrant? Is he required? Should he have gone? If he was investigating for a while, he said about a month, he had there's a confidential informant. If this was a Four Corners argument, maybe we would have been looking at the affidavit, but instead there was a hearing with Judge Green, and we heard from the officers. So, let's look at what Judge Green came up with.
Wait, are you making a new argument here that a warrant was required, that a warrantless search, even with probable cause, isn't justified here?
Well, I don't think it's a new argument. I think it's part of this to say part of the argument.
I didn't see it in the brief. I mean, I can look again.
Okay. So I'm just saying that's what stuck out on my mind was that is this where we're going?
And why would it be impermissible to do this search without a warrant if there's probable cause?
Correct.
Why would
at
it
this
be?
point, let's first get to the reasonable suspicion to stop him at all. So what do we have? We have a confidential informant, and the judge.
Can I interrupt for a moment? Can we focus on probable cause? Because you would agree, if there's probable cause to arrest the defendant, that the reasonable suspicion analysis is unnecessary.
Correct, but how did they even, what was the probable cause based on?
That's what I'm asking.
They have the person, so the CI, let's look at the CI. The information that they have is from a CI, and is he a reliable CI? That's what the judge focused on, so we can go to the probable cause part of that. She said the judge found that the police knew the identity of the CI. But did they? What was the testimony? The testimony shows that there's no information that they knew specifically the name or the phone number or how to contact the CI to be able to reach him. This CI reached out to the police officer. It's vague. So, in contrast, you'll have CIs where they have specifics about them. They'll say they want to remain anonymous, but I know who they are. So what are the factors? What are the extra factors to get from that CI looking at the veracity? The judge focused basically on, it was information not from a casual bystander. And what was the information, though, that got them there? It was, she focuses on the large amount of drugs, is what the CI said, correct? So that's that large amount of drugs. But I think that goes to basis of knowledge. So because again, what's his reliability? All he says is, this person, I went and did a buy at this house. He knows the guy as Juan. There's no confirmation of Juan living there, or if that person was just going there and leaving from a different exit of that place. He was there for 3 hours watching, and the CI gives a description of Juan, and
said Juan had drugs on him on that very day.
Drugs on him.
And had done a controlled buy.
10
days earlier, and says, Juan is mid-30s, Juan is dark complected, Juan is wearing a gray sweatshirt or shirt, Juan is wearing a white hat, and Juan is at, 226 Smith Street, apartment 1, which is what the officer observes 2 hours later when this person dressed as described comes out.
But is that enough, though? Because is that distinctive enough that he could...
Well, that's what we're here to decide.
He could just be saying, that's pretty dark-complected 30-year-old in that part of New Bedford wearing a white hat and a gray sweatshirt. There's a lot of people...
Well, but I also have to say, even if it shows that he knows something, it doesn't corroborate anything but something virtually anyone who would ever run into Juan would know.
Correct.
Right? So it's not, there's no corroboration that I can see in the evidence, although of course I'll ask counsel for the Commonwealth. I don't see corroboration of anything unlawful or nefarious.
Right.
Or anything that the CI tells them.
Right.
Go ahead. Or at least
I think
the Commonwealth didn't enter into evidence any of this stuff.
Right. So, and I think what the point I should be making more clearly is that Juan says he's wearing this, and what in the cases talk about is he could have had more information of what Juan was doing. Juan was, the officers didn't see looking suspicious, looking around, or that person knew where Juan was going. And at one point, well, now I'm getting back to that, but at one point they don't see, no, now I'm back and going to reasonable suspicion, so I got to stay away from that. He loses sight of him at one point. So, but for the probable cause point, even looking at what they know of him, what is the corroboration? And then we have the control by, and is that enough? And again, looking at the reliability, why is he reliable? Is he reliable because the police officer said he's reliable? I mean, that's all we have here from the testimony. He's reliable, so we have to just believe him.
You cite, on the controlled substance argument, you cite the Desper case, or your colleague cited the Desper case for the proposition that there was no assertion in the search warrant affidavit that the anonymous caller had been in the apartment, thus the source of information may have been hearsay. In our case, the judge found, and I believe there was testimony supporting this, that the CI had told Sergeant Lagoa that it had observed large quantities of heroin packaged for street-level sales at Apartment 1, and that Juan had narcotics on him on September 27, 2017. So I'm a little concerned that the deficiency you cite in Desper is not present in our case. How would you address that?
About the specifics of the control by?
Yes.
So the reason the site is for Desper is because the point that was being made was that the testimony was too vague. It was just saying, I did a control by and I gave him money, and then he came back and I searched him and I did surveillance of him. There was not enough. There's no detail. It's like all vague.
There's no mention that Juan was involved in the controlled buy at all.
Correct. They don't even have the right name.
No, they don't have any name.
They don't. And can I just make a point that?
Yeah. Okay. Sure.
About the CI, but the issue of the CIs, let's not forget that CIs can be made up. And I'm going beyond the record if I say that's an issue that is happening in.
But that doesn't help us.
Did you bring a Frank's motion, or did you bring a Frank's motion or any kind of motion to challenge?
Did they? No, but I don't believe he did in this case, but I'm just saying, like, in
Really
other
not
words.
before us.
But,
Yeah, how are we-
but
we
in other
can't
words,
rule
that's
on
what I'm
it.
saying, like, the CI, they're saying he's reliable, and I don't think he gave enough to show why he was reliable. So, I guess is my point, not to say that at that point, but that is something that is happening in Bristol County.
Understanding that this is a fact-specific inquiry, what is your best case for the proposition that the veracity prong was, that the deficiency in the veracity prong was not overcome
I
here?
think probably the Van Meng Joe about that they have to have specific, there's nothing specific here about Juan walking away. It's just, that's the main point. And I think the judge's decision, where I have that. When she's talking about the reliability. Sorry. She talks about, she uses the same case, Va Meng Joe, but the police observation in that case was more specific. It wasn't as vague about like what Juan was, like he would have had to say what Juan was actually doing. He was going to do this, he was going to do that. So that's the probable cause to arrest. And then also for the search, they just search him. And they testify, we weren't afraid, you know, there was no reason that they were looking for their safety. It was specifically, I know that drug people will put them in their waistband, so they immediately did that. They started asking him his name, and he doesn't speak English. So could they have made more of an inquiry to get a little bit more information? I mean, at that point, to just go and search him with that little, without the probable cause, I just don't think that's enough with the testimony from those officers.
But you would agree, if the facts support probable cause, then the search was appropriate?
Well, you would have to have probable cause for the search, which they didn't, which is.
I thought at the beginning you said, and I don't know that it's in the brief, that they needed a warrant anyway.
Well, I think that was just an aside for me, just, shouldn't have said it, maybe.
Okay, so you're not,
But I
that's
guess
not
what
yours. So your argument is if there's probable cause, they can search him.
No, the reason I'm making that point is,
Well, can you answer Judge Rubin's question?
yeah, which is why, is that, not that they needed a warrant, but in other words, what we're going off of, what we're allowing the police to do is basically say, I have a CI and he's reliable, and this, you know, but in an affidavit, they might have had more to
If there's probable
put.
cause to arrest him, then a search incident to a lawful arrest is lawful without a warrant.
Correct, right, correct.
Now, I'm not saying that they did arrest him. They did afterwards, and there are these cases about the temporal order doesn't matter that much when it's close in time. I don't know where the line is there, but there are cases like that. But if they had probable cause only to search him and not arrest him, I'm not sure that's even possible, then the question of whether they can search him without a warrant.
Right. But my point is they didn't, based on the information. But I guess my point is, going to rules and the rule of law, I guess I was thinking I would start with, but maybe it didn't go over well, is that we have to, we have rules and we have a constitution to follow, and the police have to do it. And they have to follow the rules, and he has to have someone, or testify at the hearing, he's reliable because of X, Y, Z, not, I'm up here and I can just say he's reliable. So I think that's the point I was trying to make, is that we have to hold them accountable. So I have 2 minutes, and I will quickly just touch upon the second argument about the intent to distribute. And what the Commonwealth focuses on and is really the expert, right? So the expert, and what does he say? He talks about, inartfully, more of a stronger indication.
Why isn't that sufficient evidence?
of
The
distribution.
jury has to decide. It's not an inescapable inference. But why isn't
Right.
that alone sufficient? Oh, and the $2,230 of cash in his pocket.
So that's what they-
Why isn't that sufficient to support intent to distribute? Could be for his own possession.
could
That's
be,
his
but the
argument.
argument
The
made is-
jury finds, however, that it's not.
Right.
That's pretty normal, right?
Correct, but I think here, there's no evidence of a sale, there's no cell phone, there's no, there's no paraphernalia, or I meant drug instruments.
Yes, which
Yeah.
suggests he's selling it, not using it.
Right, so the suggestion is it's just because of the testimony that the officer or the trooper made was that it could also be, it could have been as well a seller. A user. And the expert got a little too close with his testimony. And one point I want to just make, and now I have 18 seconds, but what I picked up on was he is supposed to just give general information to the jury, and not specifics on this case. And the prosecutor took out a picture and is showing him the actual evidence in the case and pointing to it and asking him questions. And then he makes his,
Was an objection made? Did you raise this in your brief here on appeal?
but no objection was made, but that's something to consider, where he's basically saying, and that argument is in the cases cited, Cephas. And I see that my time is over, so I will rest on
Your
my
time
brief.
has expired. Thank you very much.
Thank you.
It's a helpful argument for us, and we will hear now from Attorney Kidd.
Good morning, Your Honors. May it please the Court, my name is Rob Kidd. I'm a prosecutor at the Bristol County DA's office. So the evidence starts out with a tip from a confidential informant who says that this person, Juan, is selling heroin out of the apartment 1 at this particular
No, he
address.
doesn't say out of apartment 1. He says a guy named Juan is selling heroin in New Bedford, heroin and fentanyl or fentanyl in
But-
New Bedford.
If I may, Your Honor, I'm just going to check my,
Yep.
I'm not questioning it, well, I am questioning, I'm just going to make sure that you're correct, but
Actually, it motioned to the transcript, Volume 1, page 14. What information did you learn this particular date that drew you to that location? CI contacted me in regards to the male under investigation. He identified as Juan, currently selling heroin at this location.
Okay, but that's the second time. That's not the initial time. The CI, are you talking about when the CI first comes to
Yes,
the police?
yes.
Yeah, I think he just says New Bedford.
I'm just going to,
Selling heroin or fentanyl throughout the city of New Bedford is the first.
yes, okay. I think the first time you may be correct, Your Honor. It says, I'm looking at the judge's findings, which is from the motion, but during that investigation, a confidential informant advised Lagoa that a man named Juan was correct, selling New Bedford or fentanyl throughout New Bedford from apartment 1 rear at 224 Ashley Boulevard. So that's what I have.
Wait, when did he say, I thought that address was given to him, the CI, by the stranger he called at the police's instruction?
No.
What page of the transcript?
I'm looking at the judge's findings, Your Honor.
The judge's findings are wrong.
Well, they may be. I'm just saying, that's what I have in front of me.
Okay,
I don't-
but that's wrong. I'm looking at I don't see any mention. I found the judge's findings odd because it's a bunch of stuff that I don't see in the transcript, but maybe I'm wrong. I thought he got the address. My understanding, and obviously I want to be corrected because this is the whole case in a way. I thought he comes to the police and says a guy Juan is selling heroin or fentanyl or both throughout New Bedford.
He says that. He does definitely say-
And then the police have him call someone he doesn't know and they don't know. He calls that person. That person directs him to that rear apartment.
Correct.
Okay, so then he goes, and it's called a controlled buy, but we don't know who he buys it from, because it's not like he comes back and says, yeah, that was Juan. Maybe he did, but it's not in the testimony. So I don't know what is corroborated by him successfully buying drugs from someone or someplace that the police have given him the information about. I don't, except that drugs are being sold from that address.
That's the essential, and I think that's the essential thing that's corroborated. It's the fact that that address is where heroin is being sold, and it's that same address where they did the controlled buy, where the informant went in from. That very same address is where the informant called from a later date and said, I'm here at that address. I see he's here now, or whatever he says. He's here. I see drugs packaged for sale. And it's at that point that the defendant leaves that apartment, and police stake out, and lo and behold, that a person did emerge from that apartment. He was the same person that was described with the clothing, the same skin color, the same clothing. I understand those are not, suspicious details, but when you look at it in the terms of the entire case, there is corroboration that it all fits into this.
Well, so I'm just trying to figure out how anything that the CI told them, anything, was corroborated prior to the stop.
The CI told them that heroin was being sold by this guy Juan throughout the city of New Bedford.
Okay.
Like I said, I have indication from the judge's findings that he said it was from apartment 1, but that may be incorrect.
We'll both look.
Yes.
Yeah.
So now police have this information. They now do a controlled buy that is monitored by the detective. He says, I watched him, and the findings say that the police officer is near apartment 1. He has the apartment 1 in his rear view mirror, and the information is that he searches the informant. The informant goes in, and then... Well,
but the informant isn't corroborated by that. If the informant didn't tell them apartment 1, then it's not corroborating something he told them. He's just doing a buy for them at apartment 1. Then he makes this second tip. I'm trying to figure out why he's reliable when he makes the second tip, right? He has to be reliable by then for them to rely on it, right?
Well, when he makes the second, when he gives the second tip, first of all, I would point out that as far as basis of knowledge, the court, I think, needs to credit the information a little bit more than...
Oh, I think he gets basis of knowledge. Eyewitness is his basis of knowledge. He says, I was in the apartment and saw drugs. That's a perfect basis of knowledge.
Correct. And that is corroborated by the fact that he's in the apartment where the drug...
Well, I don't know if he is or he isn't. He says he is.
Yes. That's what he says, and he says that this individual Juan, and he's wearing certain clothing, and lo and behold, from that same from apartment 1, out comes this same individual who he described after he had seen the drugs.
But if I know where someone lives,
what's that?
If I know where someone lives, which anyone can know, I could find out probably your address or my colleagues' addresses or whatever, and I call the police and say, you're going to find a gentleman. He's going to be wearing a nice gray suit and an orange tie, and he's going to be it's going to be about 5:30 in the afternoon. He'll get back to this place, and that's where he keeps the drugs I've seen. I mean, that's not probable cause describing you and what you're wearing.
Well, I mean, there's case law that says that somebody could theoretically fabricate an entire, description or whatever if you know somebody. But in this case, you need to look at both the controlled buy and the informant's original information and the informant's observations at the time. They all fit. They all indicate that heroin or fentanyl or these drugs are being sold out of that particular address in New Bedford.
But is that enough? So 10 days before someone buys drugs out of this apartment, let's say, I don't think he was monitored. We can't tell how well monitored he was, but let's assume he was monitored well going into that exact apartment, coming out, they search him, and now he has drugs. It appears that he bought them in the apartment. So we know the apartment is being used for drug sales. Is there probable cause to arrest anyone who comes out of that apartment?
No, but there is probable cause to arrest somebody if there's drug activity going on the same day, and the same informant talks to them and says, you know that same apartment that I told you about? I'm here now, and this guy has drugs on him. Those two things have to be looked at together. When you look at those together, I suggest they provide adequate corroboration. That, in addition to his tip. I mean, that's the case. That's basically the Commonwealth's case.
If you only have reasonable suspicion here, can this search take place, or there has to be probable cause?
There has to be probable cause. The search, yes, the search is the pat frisk, and I did look into that, and I think counsel's brief is correct. I think it has to be a Terry stop.
Yeah, you'd have to think armed and dangerous, or, yeah, I
It's
see.
not a Terry situation.
I asked your colleague this question, so I'll ask you the same one, which is, again, understanding that this is a fact-intensive analysis, is there any particular case you'd like to draw our attention to for the proposition that the weakness in the veracity prong here was overcome by additional information?
I'm glad you asked me that, Your Honor. I'm just kidding. No, I did happen to think that might be a question. And I would direct the court to Commonwealth versus Montero. It's in my brief. It's 93 Mass Ave. I forget but anyway.
We have it. Thank
that was
you.
a case out of Bristol County, and that was a search warrant case. And that involved a first-time informant who had never been used by the police. Here we have an informant who the detective says is quote-unquote reliable, although there's a paucity of detail as to why that is the case. In any event, you have a first-time informant in Montero, and you have a single controlled buy, as you do in this case, and you have a deficiency in that controlled buy, as you do in this case. And as in this case, in Montero, the deficiency, I suggest that the main deficiency is that police in Montero don't see the defendant actually come out of the door of the apartment building. They see him like come from around the back of the apartment building or something. That happened to be my case on appeal, so I'm very familiar with the facts on that one. But it also fits nicely, I suggest, into the Commonwealth's argument. So in that case, the court said, in Montero, the court said, despite that deficiency in the controlled buy, we're going to follow DESPER, and DESPER specifically has language in it saying that, if one of the elements of the controlled buy is missing, then, it can be overcome. Although, admittedly, the officer's testimony is vague as to the controlled buy. I understand that that's the case. But as we said in our brief, he said he monitored the controlled buy, maintained constant surveillance. He said there was, he searched that if the informant gave him money, and, I suggest it's enough. And so Montero's the case I would direct the court to. I don't know if there's any other questions. As far as the second issue, if the court wants to move on, I don't really have much to say on that. I'll rest on my brief as far as the second issue is concerned, which is the sufficiency of the evidence. And I'll ask the court to. Nothing further. No more questions then?
I see no further questions. Thank you very much. Excellent argument from both of you. Very helpful to us. And the case is submitted.
Thank you, Your Honor.
Yeah, that's what's going on right now. That's exactly right. The next case we will hear is number 23-240, and it is Commonwealth versus NJUGUNA. And we will hear first, I should be better at this by now, but we will be hearing first from Attorney Power.
Thank you, Your Honor. Good morning. May it please the Court. Andrew Power for Defendant David NJUGUNA. I'll begin with Issue 2, the sufficiency of the evidence. Your Honors, no view of the evidence supports a finding beyond a reasonable doubt that wanton and reckless conduct caused this crash. We can speculate about the reasons for the crash, but speculation is not proof beyond a reasonable doubt. A crash itself is not sufficient to prove a crime. Now,
What about the testimony of the speed at which the defendant was driving, both before the crash in the earlier time when he was passing individuals and was seen crossing 3 lanes, driving, I forget the expression, but incredibly fast and dangerously. And then immediately before the crash, where he again was seen driving at a rapid speed, much faster than the people driving, I think they clocked themselves at 75 miles an hour, 70, 75, and he was going faster. Went across all 3 lanes, went into the breakdown lane, was seen to straighten out and then hit the person. In addition to the expert testimony regarding the speed at which he was going. And why don't we stop there for now? Viewed in the light most favorable to the Commonwealth,
Yes,
why
Your
doesn't
Honor.
that get the Commonwealth over the bar?
Okay, you've given me a lot to work with. Let me break it down a little bit, if I may.
Well, the more you have to break it down in some sense, the tougher your case is, because again, we have to view it the light most favorable to the Commonwealth, but go ahead.
Okay. So the speeding itself, and I accept in the light most favorable to the Commonwealth that he was traveling 81 miles an hour. That was established by the expert testimony and also by some of the...
Minimum of 81.
Minimum of 81.
When he
passed-
collided with the, well, there was no braking, so yes.
There's no
okay.
braking, so he
Yeah, no.
roughly 80s, let's say. Now, speeding per se is not reckless.
Driving in the breakdown lane might be.
Absolutely, absolutely. But speeding itself is not reckless.
Weaving in and out of traffic, crossing over 3 lanes, cutting people off, all the different testimony, but go ahead.
Okay, so we have the eyewitnesses who testified that my client, at the scene of the crash, was going fast. He passed one of them like he was stopped. None of those individuals, Mr. Lindsay, Mr. Sorrentino, and Mr. Russell, saw my client weaving, tailgating.
Well, wait a minute. One of them saw him move and stay briefly for a car length in the center lane before continuing to the right, which isn't a car out of control simply careening across 4 lanes. If he stops even for a little while and drives straight, then he's in control of the vehicle, and maybe, again, in the light most favorable to the Commonwealth. And unless I'm mistaken, and Judge Neyman mentioned this too, once he gets into the breakdown lane, there's testimony that he straightens out. I think, is there? I think there is. So if he's in control, I mean, of course, this comes down to, I guess, the question for the finder of fact. If he is in fact having a medical emergency of some kind and is not in control of the car, then maybe he wasn't driving recklessly when he crashed into the vehicle. But if he was in control of the car, then driving over into the breakdown lane at that rate of speed and driving on it is reckless, right?
The question is, what is the reason for what he was doing? First of all, as far as the testimony
Trying to
by
get
Mr.
someplace really fast, maybe.
In the breakdown lane? I mean, the left lane...
Look, I don't know anything about how he ordinarily drives.
The left lane-
I have seen people drive in the breakdown lane. I always think it's a crazy thing to do. I haven't seen anyone do it, I don't think that I can think of, that fast and with a car with flashing lights on right there. But I don't know what he was attentive to in the car or not.
As Your Honor pointed out, it makes no sense. And let me just get back to...
Well,
what you said
unless
about
it's
the movement
completely
of the car.
reckless, like if you told me, and I don't think there's any evidence of this, but if you told me someone was texting, I might say, oh, then their eyes weren't on the road. If you tell me someone is smoking weed, getting the weed out of the bag and smoking it, and I understand he was acquitted of the charges about impairment from marijuana, but there were 2 partially burned marijuana cigarettes that he had, at least in the light most favorable to the Commonwealth, that he had just bought in Brookline, right? People lighting a cigarette or a joint in a car might not be paying attention, right?
There was no evidence that he was smoking weed in the vehicle because nobody detected the odor of marijuana in the
There
vehicle.
were partially burnt joints, right?
But
2
there
of
was
them.
no evidence as to when they were consumed.
As far as the sufficiency of the evidence is concerned, what do you concede is the evidence in the light most favorable to the Commonwealth? You've said speeding, and then we know the case law, speeding alone isn't enough. But what else of all the behavior that the jury could have found the defendant to have engaged in, do you concede, is on the Commonwealth side?
I concede, according to the testimony of the witnesses, that he was driving in the left lane at 81 miles an hour or more. He veered or darted across the highway at high speed. Now, whether there was a steering correction or not, I think is a matter of opinion. That was not a question of fact. And if you let me explain, the witness, Mr. Lindsay, testified that my client spent half a car length in the center lane, going at 81 miles an hour. A car length is about 16 feet. That's a fraction of a second. For all practical purposes, he was moving across the highway at high speed and into the breakdown lane. Now, any sane individual seeing grave danger ahead would have used the brake, swerved in another direction, turned the wheel. He didn't do so. There was no evidence of suicidal ideation. There was no evidence of anti-police bias. There was no evidence of
We're not
psychosis.
talking about involuntary operation. We're just talking about the operation itself of the vehicle.
Right.
What evidence do you concede
Okay,
in the
so
light most favorable to the Commonwealth?
So going back, I do concede that he swerved across the highway at high speed, crashed into the cruiser, entered the breakdown lane at some point. I don't know what the light most favorable to the Commonwealth is. You know, if he entered at 100 yards away, he'd spend about 2.5 seconds in the breakdown lane. If he entered right before the cruiser, you know, split second, I don't think it really matters, but take it whichever way you will. I concede that he entered the breakdown lane at whatever point the Commonwealth thinks is more favorable to them. I still don't think there is, and I concede that the car turned in that direction, but they characterized it as a steering correction, and a correction implies making something better or an adjustment to fix something. And a correction in this circumstance would have been stepping on the brake, turning away from the cruiser.
But the
He did
premise
not
of
do that at
the
any
premise
time.
of everything you're arguing, and obviously it's good, right? I mean, you're correct if this were the case, is that no one would do this if they saw the cruiser. If they saw something in the breakdown lane, then no sane person would do this. So isn't the alternative hypothesis, he didn't see it, he wasn't looking, or he wasn't paying attention properly, and he didn't see it? I mean, or he might have been impaired, but I know he was acquitted of that. But for, right?
Again, in the light most favorable to the Commonwealth, it was the Commonwealth's position that the cruiser was clearly visible in the breakdown lane.
Only
They
if you're
had
looking.
a visibility study. Their
No,
witnesses
I have no
testified
doubt,
repeatedly.
right? I mean, it's flashing blue lights in a breakdown lane, and of course, this is one of the reasons no one should ever drive in the breakdown lane. Although there's some roads here where during rush hour, for whatever reason, the Commonwealth allows that. But you have to be looking to see something obviously visible.
But again, it's speculation to suggest that he wasn't looking. And speculate, that's what the Commonwealth actually argued in closing argument. The Commonwealth, the prosecutor argued that he was reaching across to something in the passenger seat, either his inhaler or smoke or something, inadvertently crossed the highway, hit the rumble strip at the edge of the breakdown lane, corrected himself, but did so too late and slammed into the cruiser. Now that is the fact scenario of Commonwealth v. Hardy. That is controlled by Commonwealth v. Hardy, which states that inadvertence is not wanton and reckless conduct. In other words, he was not driving incredibly. Commonwealth v. Hardy, the defendant failed to stop in time to avoid a trailer, swerved out of the way, hit the guardrail, bounced across the double yellow, and hit a car in the oncoming direction, causing 2 deaths. It's also similar to Commonwealth v. Mary.
But when you say inadvertence, if someone is already driving wildly fast, and maybe it's fair to say that alone isn't recklessness, although I find it hard to believe that if someone's driving 105 miles an hour on the Mass Pike that they aren't being reckless. And I'm not saying he was driving 105, but it seems to me, yeah, speeding might not be, but at some point speeding could be. But let's say he's in the speeding range that's not by itself reckless. Speeding and not paying good enough attention so that you inadvertently hit something, why isn't that recklessness? I'll look at Hardy, but...
I would say wanton and recklessness is a common law concept. And it would be vague unless it were defined in the case law by actual examples of recklessness. And the recklessness that we find in the case law is not inadvertence. If you look at cases like DeSimone, Moore, Hardy, Guaman is a good example. Those are examples of a clear disregard for the obvious risks, a continuing disregard for the obvious risks of danger arising from that conduct. In other words, DeSimone, where he's playing cat and mouse with another car, causes a crash with that car. That's wanton and recklessness in the context of an automobile accident. Moore, he's trying to escape the police. He's leading him on a high-speed chase through rush hour traffic. Creates a big pileup at an intersection. That's wanton and recklessness. Guaman, same thing, hits a motorcycle rider and drags that rider while fleeing the scene where everybody can see that the person is screaming for help. That is wanton and recklessness. This case is not wanton and recklessness. It is not the same conduct. If you compare it to the case law, I mean, this may be the first case that defines it that way, but prior cases do not define wantonness and recklessness in terms of reaching for the inhaler, looking up, and, oh my God, hitting the cruiser in the breakdown lane.
Before your time is up, I'd like to ask you some questions about the involuntary manslaughter, misdemeanor homicide.
Yes, Your Honor.
So you cite the case of Commonwealth versus Jones, and my question for you is Jones an outlier? And by outlier, I mean this. Jones the SJC held, that the legislative history shows that the legislative intent was to create a middle ground crime in motor vehicle homicide, and therefore, we're not going to punish people for both misdemeanor homicide and involuntary manslaughter. Are you with me?
Exactly, yes.
Are there any other cases where the SJC has applied that rule in this context?
Not that I know of.
So
I've
Jones
looked
is
at
a standalone, and the only case in which that applies is with involuntary manslaughter and motor vehicle homicide, correct?
them. Yes.
Okay. And as I understand your argument, then, it's that while Jones may be an outlier, it's still good law.
Yes. I would say that the case that I cited in my reply brief, Guerrero, from the teens, mid-teens, I think.
2013.
2013 did cite Jones with approval, indicating that Jones was still alive in 2013 at least, after some of these other cases like Buckley that had knocked Jones had already passed and been abrogated. So Guerrero follows Vic, and Guerrero acknowledges that
By
Jones
follows Vic, you mean it came after Vic?
Came after Vic,
It
yes.
actually
Does not follow
reveals
Vic.
an ongoing exception to Vic if you interpret it that way.
It's an exception. And
Can I
think
ask you this? The Commonwealth, arguing that you're mistaken about that, about those two crimes, says that the operating to endanger is duplicative of the negligent vehicular homicide. If we vacate the negligent vehicular homicide, you don't argue that operating to endanger is duplicative of the involuntary manslaughter. Is that right?
Under
That is, we would
Jones-
just knock out the negligent homicide, but the operating to endanger would remain.
No, Your Honor. My understanding of Jones's holding, which was the actual order in Jones, was that the three charges go to judgment, and then once there's a verdict, the judge takes out the two less serious charges and then enters judgment on the most serious charge.
And the first one he knocks out because of statutory construction of the negligent homicide law, and the second one is simply a lesser included offense.
Yes.
Okay. Your time has expired. Very interesting argument. Thank you very much.
Thank you, Your Honor.
Very well argued. We will hear now from Attorney Haran.
Good morning. May it please the court, Donna Marie Herron, Assistant District Attorney representing the Commonwealth. I'll go to the second issue first. There was more than ample evidence presented to establish the defendant's convictions for involuntary manslaughter and motor vehicle homicide, as Judge Kenton Walker found in her rulings, which she wrote out, that the defendant drove his vehicle at excessive speeds, tailgating at excessive speeds, weaving in and out of traffic, passing cars too closely in an extremely dangerous manner, and weaving in and out of traffic. He then crosses over 3 lanes of traffic going well over 81 miles an hour, drives the car into the breakdown lane, where he then straightened his car out and slams into the back of Trooper Clarity's cruiser. This is more than enough evidence to establish wanton and reckless conduct. I would direct you specifically to Sergeant Samantino's testimony, where he, I believe, stated he was driving in the breakdown lane long enough for him to think, what is this guy doing? Why isn't he stopping? Why does he had those internal thoughts in his head. He testified to that. Mr. Lindsay testified that he saw him straighten out his car in enough time and slam into the back of Trooper Clarity's cruiser. That, plus the observations earlier of Mr. Jenko and Mr. Bratoff, I would say more than sufficiently established the wanton and reckless conduct. I would suggest the case law, D. Simone, Moore are good examples, and I suggest Hardy is a good example of, to contrast that. In Hardy, the Commonwealth's theory of wanton and recklessness was the defendant's failure to properly secure her children, who were the 2 people that died in the accident in their car seats. And the court found that that was not wanton and reckless conduct, that she only drove in a negligent manner, and the failure to secure her children in the car seats properly was not wanton and reckless conduct, which I would suggest is wholly different than this case here, and would ask you to affirm the defendant's conviction for involuntary manslaughter.
I'm sorry to interrupt you. On the Jones issue,
Yes.
in light of the Suero case,
I have to admit, I didn't read that case. I apologize.
have you read it now?
No, I did not see that in his reply brief. I do apologize for that. I stick with that Vic has made it crystal clear that the Maury element-based test is how you determine whether something is duplicative. Buckley, I know, was overturned on different grounds by the SJC, also explicitly stated.
But Jones...
Seeming-
No, go ahead, Judge.
Seemingly, you would be correct on Vic, but the SJC subsequently, in Suero, indicated that in other criminal contexts, this court has determined what they say is the key issue is whether the legislature intended to punish conduct for 2 or more charges where the conduct may have constituted one criminal act, see Commonwealth versus Jones. It's one example of 2 that the court gives in Suero of exceptions to the Vic rule. So assuming, without deciding because we haven't made a decision, but assuming that we were to hold that under Suero and under Jones, the motor vehicle homicide conviction cannot stand.
Okay.
What happens to the operating to endanger? Is that also out?
I don't think so, because that, I conceded that is duplicative of motor vehicle homicide, but the operating to endanger, I do, well, again, under the Vic-Maury test, has different elements than involuntary manslaughter.
So you think that the only thing that might... Okay, so...
You're just saying the middle ground crime gets knocked out, but the lower crime can still stand with the higher crime. Those are not technical legal terms.
No, because
by the way.
Jones was also not, yes, I believe that.
What are the
that would
extra
stand.
elements of each?
So to convict on involuntary manslaughter, which Jones specifically also states in there that they're not duplicative crimes, by the
No.
way, that the defendant intended to cause, that the defendant caused the victim's death, the defendant intended the conduct that caused the victim's death, and that such conduct was wanton and reckless, while in negligent operation, we have operating a motor.
No, I'm asking about the driving so as to endanger.
Well, the driving, so the driving to endanger would have operating on a public way negligently or recklessly. I believe would be the things, which would be different than intending to cause the defendant's death.
All right, so I understand there's extra in the manslaughter, obviously there's death.
Yes.
Which isn't a part of driving so as to endanger. And you're saying the driving is the additional?
Yes, on a public
I
way
see,
would
okay.
be the additional elements that are not
Okay.
in the involuntary manslaughter. If there are no further questions, the Commonwealth will rest on its brief and ask this court to affirm the defendant's conviction of involuntary manslaughter and affirm the order denying the defendant's motion for a new trial.
Are there further questions? No, I see no further questions. Thank you very much. Very good argument, very helpful to us. The case is submitted. The next case we will be hearing, I may pronounce this name wrong, is Commonwealth versus STRACHAN, number 22517.
May it please the court? May I begin, or?
Yes, please.
May it please the court, Carolyn Burbine for the Commonwealth. It's our position that the motion judge erroneously granted the defendant's motion to dismiss the complaint. 2 counts of
I'm going to ask you to
possession.
speak up a little bit,
I'm
please.
sorry.
That's
It
okay.
was for 2 counts of possession of a controlled substance. We feel that the judge misinterpreted General Laws, Chapter 94C, 34A, to provide immunity from prosecution to a defendant in the scenario here, where...
Let me ask you a hypothetical off the top. Assume the exact same facts, but Officer Ramsey is an off-duty police officer, but everything else is exactly the same. And off-duty police officers, I believe, have an obligation, even when they're off-duty, to assist and help and conduct themselves as if they were on duty. Could the defendant, under the scenario I just gave you, be prosecuted, or would he be immune under Section 34A?
I don't think he would be immune because it's our position that this statute is designed to apply to, I mean, if you just look at the title, you read it as a whole, but you also look at the title says immunity from prosecution. And it's for persons seeking medical assistance for self or other experiencing drug-related overdose. So that police officer doesn't...
Off-duty.
Off-duty doesn't need immunity from prosecution. There's no issue. He's...
Wow.
So let me back up for a moment. We start with the construction, we look at the language, and if it's clear and unambiguous. So you're saying that 34A subsection B is not clear and unambiguous?
Right, because I would...
Pretty clear to me,
I
even
don't
though...
think it, I feel it's clear, but I think that this whole, you have to look at the purpose of the statute, the reason it was enacted.
Do we get to
No,
purpose
we
if the
don't,
language
right?
is unambiguous?
Well, I think when you, any kind of statutory interpretation, you want to discern the intent of the legislature, don't you? You have to give it an effect.
No, we don't, I think.
I was under the impression as long as it is not
Absurd.
an absurd result, that if the language was unambiguous, the rule of statutory construction is we go with the plain language, but I could be mistaken.
Yeah, you're right, it's conclusive. If it's clear and not ambiguous, it's conclusive as to the intent of the legislature. You're correct, I'm sorry.
So in the hypothetical that Justice Neyman just gave, the off-duty police officer, a couple of things. One is that subsection B is not about immunity for the caller. Subsection A is, right? But subsection B is for the person who's experiencing a drug-related overdose. It's immunity for that person.
Right.
So the suggestion to Justice Neyman that no, the officer wouldn't need immunity, B the caller, whoever that person seeking medical assistance, isn't the one getting the immunity, it's the person who's overdosing.
In B, yes.
Right. And that's what we're dealing with right here, is 34, large A, small b, subsection B. So if we're to read the statute as such, how is it an absurd result that the person who's overdosing doesn't also get prosecuted because saving lives in this situation is more important than a straight possession charge?
Well,
Is that absurd?
I think the problem is that we have to read it as a whole. So when you see that clause, seek such medical assistance.
Can I suggest for a moment that we don't? So if it's clear and unambiguous, so long as that the result isn't absurd or illogical, right?
But it's our position that I'm sorry, but I would disagree that you have to read it in conjunction with A, and so that if you tie B back to A, that doesn't fit this scenario.
We also are required to look at the language, and the case law is clear that if the legislature wanted to carve out an exception for law enforcement, they could have done so, correct? So they didn't exclude police officers or law enforcement on or off duty in this statute.
Again, our position is that if you read it as a whole, police officers, the necessity for this statute it wouldn't be intended to protect police officers where police officers already have the community caretaking function. So it's already part of their job.
So you're saying Part A doesn't protect a cop who calls in?
No, what I'm saying is, if you look at the whole point of the legislature's desire to even create this 34A, what was the remedy that they needed, what was the problem that they felt they needed to correct? In all of these scenarios, police officers always have that community caretaking function, whether they're off duty, on duty. They already have that function. They're not going to face any penalties for making those calls.
Okay, what if I change Judge Neyman's hypothetical a little bit, and now the off-duty police officer is a drug addict, and he's doing drugs with the defendant in some apartment somewhere. They're doing heroin, both of them in the apartment, and the defendant overdoses. And the officer is completely freaked out, but he calls 911 because he's not going to let the other person die, even though he's going to be caught with drugs and so on. Does it apply in that case?
It probably would have to, but that can't have been what the legislature was concerned about. The concern would have been.
Well, but you say it applies. I understand it may not be the center of their concern, police officers.
I mean, you don't want to discourage anyone from, the whole point is not to discourage anyone from calling for help.
Mm-hmm.
All right, so let me ask you this hypothetical, because the cop is on routine patrol. He sees someone slumped over and experiencing an overdose. Takes out a spray can of Narcan and resuscitates. Doesn't call anybody, just does it. Part of his job, right? He sees fentanyl, heroin, you name it, all in the car. Does the driver, slumped over, who now is back to life, does immunity apply?
I would say it doesn't look like it.
Because the officer didn't seek medical?
Exactly.
Okay.
Right.
So now the cop's on routine patrol, but this town doesn't have Narcan. Or tries Narcan, it doesn't work, so he calls the fire department. And the paramedics have a stronger dose, Narcan or whatever. Drugs are found. Immunity applies?
To the defendant? No, that's our situation. He's
To the
came
driver?
upon him.
Right. So how do you differentiate the first one? Cop on patrol, sprays the Narcan to the driver who slumped over because he's overdosing, but he didn't seek medical attention, right? He just did his job.
But that's how the statute is written. I would have to, I mean, if you're really going to interpret it the way it's written, if he didn't seek the medical assistance, the defendant doesn't get the benefit. If he does seek the medical assistance, he does.
Hypo 1, you agree with me, immunity doesn't apply, right? Hypo 2, cop on patrol, left his Narcan at home. Person's overdosing. He dials 911, fire department comes and saves the driver. Does immunity apply?
B doesn't, the defendant doesn't get the immunity, no, because that's our scenario, and that's my argument, is that he would not get the benefit.
And the reason why he doesn't get immunity is why? In the first one, you said immunity doesn't apply, not that police officers are exempt from 34A, and it's not a question of immunity.
I think it's who you're trying to protect here. The whole goal here is to protect people who face penalties.
No, you're protecting the driver slumped over. So A, you're protecting, and A, you are definitely protecting the caller. No doubt about it.
Right.
Right?
Right.
B, you're protecting, we're just going to call, for sake of this argument, the driver, the person overdosing.
Right.
So if I'm to accept your argument, the one-stop shop with the police officer spraying Narcan, everybody gets charged. But if it's a town that doesn't have Narcan and he's got to call in the paramedics, then
That's how the statute,
so then neither could be the statute.
I'm sorry?
Then neither hypothetical could fall under the statute, right?
Well, the first one, well, no, exactly, yes, neither one could. But I think when you interpret B, you have to go back to A for who is, it has the language, or is the subject of such a good faith request for medical assistance. I would suggest
Why do
that
you
ties
read it
back
that
to
way?
A.
So it doesn't say or and it doesn't reference as referenced in subsection 34A, small a. There's none of that. You're taking the word such.
Or is the subject of such a good faith request. I'm arguing that that is a reference back to section A, because you have to read it as a whole.
But if
Subsection A.
If you look at the beginning of paragraph B, even before that clause, they already use the word such, right?
But it's still,
So how is it not independent? You
Because-
look at the other sections, does subsection E apply to police officers?
which one, I'm sorry?
Subsection E?
E?
Subsection C says a person acting in good faith may administer naloxone to an individual appearing to experience an opiate-related overdose. Could a police officer who gives Narcan or administers naloxone to someone experiencing an opiate-related overdose
Could
take
they,
advantage of that? Would that apply to a police officer?
well, according to my interpretation, that throughout here, when we're talking about the person who in good faith refers to non-police officers, I'd have to say no. But the police don't need the benefit of that anyway, because they have
Well,
the
you
authority
said
to
police
give
don't
net.
need the benefit, but in my example where the police officer is doing drugs with him, he needs the immunity. Or he may not be entitled to it, I have no idea, but
Right.
then maybe he's not
He may
going to
not be
call.
entitled to it.
Yeah, but he may also not call 911 if he's not entitled to it. And presumably, the legislature wanted whoever's with the overdosing person to call 911.
But I just, the way, we're interpreting it is that this is not directed at, this is directed at drug users and their companions who may feel that they shouldn't call for help because
If they use
of,
the word companions in the statute, I think you'd have a stronger argument. My problem with it, looking at the language, is you want us to say a police officer is not a person, right? And so if they're not a person, I'm not sure exactly what I would call them, first of all. But secondly, if we're looking at the intent of the legislature to the person overdosing, do you think it really matters whether or not it's the cop who called or the buddy that he or she does drugs with?
But there's not giving cop, you know, it's, the goal is not to give just complete protection from possession charges. It's under certain circumstances. So I still think that the legislature, had they wanted to say, you know, something special about police officers, would have included language that was special about police officers. I don't think that this at all even contemplated a scenario like ours, where there was a police officer who already has the community caretaking function. It's already part of his job. None of this will be a concern of his. If it's a police officer, the person is going to get what they need. And what they wanted to do is give a safe harbor to people who use drugs and their compatriots so that they wouldn't hesitate to call, and therefore people would be saved. I don't think the legislature, just looking at the title, it's immunity from prosecution is the title. That's the concern. It's police officers aren't going to get prosecuted for doing what is their job, which is community caretaking.
Well, let me stop you right there.
And then-
So let's say that I was the person who came across the defendant in the Burger King parking lot at 2 a.m. Exact same facts. I knock on the window. I see the person isn't responding. I mean, I'm not doing drugs with the person. I'm acting, so I'm not about to be charged with possession of drugs because I had nothing to do with it. I'm just a good Samaritan.
Right.
By your logic, then I wouldn't need...
But what would prevent you from calling? Like, you wouldn't be afraid of anything, you would call, presumably.
So
you
he
don't
would
need
be
this
immune as well
statute.
under your theory. Good Samaritans are immune,
No,
don't...
but I'm saying a
I'm
person...
saying I wouldn't need it, but who knows?
Well, but the driver
Well,
needs
you're
it.
you're a person in good faith who sought, so you would fit under A. But even, well, but you don't need the immunity, so you would, I mean, we don't have a Good Samaritan law that requires people to act in these
The driver is
circumstances.
the one under B again. So under Justice Neyman's example, regular old person sees what is seen and calls for help. Does the driver get immunity under B?
Under B. Under my interpretation, no,
I come
because
upon
it
the
applies.
person, I call 911 and the fire department to help the person. They come, they administer Narcan, they save his life. Does B apply? Does the defendant...
No, because you weren't someone was facing a problem with a potential penalty.
Okay. Your time has
Thank
expired.
you.
I think we understand your argument unless there's
No.
more. Okay.
Thank you.
Very good. Thank you very much, Attorney Burbine. Very good argument. We will hear now from you, Attorney Frades.
May it please the Court, Mike Freites for Mr. Strahan.
Speak up, please.
May it please the Court, Mike Freites for Mr. Strahan. Imagine you have imagine a scenario where you have two Burger Kings, two vehicles, and two individuals overdosing in the driver's seats of those cars. Why would we treat one overdosing individual different from the other? The Court is right. 94C, Section 34A, subsection B addresses the overdosing individual. And it is, I disagree with counsel where I believe it's hard to imagine the legislature under these circumstances wouldn't have anticipated first responders making that call. And if they chose to exclude first responders, they could have. The Commonwealth would prefer to make this argument about the police officer seeking medical assistance. So they're arguing in their brief that the good faith clause associated with Section B is an extension or somehow related to the good faith clause associated with Section A. I see no reason to make that connection.
Let me ask you a question. Does it matter in this case that the police officer, before making the call, observed the drugs next to the defendant in the vehicle?
Excellent question. It was in plain view. The drugs were not in plain view, Judge. They were in the center console, but
Probable
the crack
cause
pipe-
standard, he said he saw them in the console, so assume for the sake of argument he sees the drugs prior to,
Well, Judge, according to
making the call.
According to the transcript and the judge's findings, the drugs themselves were the result of an inventory search. It was
We're at the probable cause stage, right? Here?
To search for those drugs, sure. They found them during an inventory. So what was in plain view was a crack pipe and an empty cellophane bag.
We're bound by what's in the application for complaint in the police report,
Yes.
correct? That's our relevant universe.
Yes.
The police report indicates that the officer wrote in the police report that he saw the drugs before he made the call for help.
Okay.
So those are the facts that we have to apply in our probable cause analysis. I want you to assume that.
Yes, Judge.
Okay? Does it matter that he saw the drugs prior to seeking medical assistance?
I don't believe so, Judge, and the reason I would argue that is because the reason those drugs were there was as a direct result of the usage that resulted in the overdose.
So let me explore this a little further with you. Can we agree that paragraph A, sub A of 34A, applies to the Good Samaritan, to whomever is the person who is not ODing but is seeking medical assistance on behalf of that person?
I would argue that includes a police officer or any first responder.
Yes.
Yes.
Can we agree that
Yes.
that's what sub A means? Can we agree that sub B applies to the person experiencing the overdose?
Yes, Judge.
Okay. Under sub B, the second clause says, or is the subject of such a good faith request for medical assistance. I want you to assume for purposes of my next question that such good faith request speaks or modifies paragraph sub A. Are you with me? Sub A applies to a person, says, a person who in good faith seeks medical assistance for someone experiencing a drug-related overdose shall not be charged if the evidence for the charge of possession was gained as a result of the seeking of medical assistance.
Yes, Judge.
If the officer saw the drugs prior to seeking medical assistance, then was the evidence here gained as a result of the seeking of medical assistance? How can that be?
I believe it was so, Judge.
How
because
so?
Wait, the language is different in subsection B. In subsection B...
I'm asking about subsection
Yeah,
A,
but
though,
that-
right now.
Okay, but that's about, they aren't charging the cop.
I'm asking about subsection A. I'll get to subsection B.
Okay.
The cascade of events that resulted in that police officer seeing those drugs were the direct result of an overdose. Had it not been for that overdose, that vehicle would never have been there.
So you're not interpreting it as proximate cause, you're interpreting as a result of much more broadly.
The intent of the statute in the defendant's position is that it's to offer a safe harbor for those people who are overdosing and therefore interpret this event as a medical necessity and not a criminal matter. So I would argue that, yes, I would argue that.
Why would the statute under sub A require the additional language if the evidence for the charge of possession was gained as a result of the seeking of medical assistance? Why does the non-ODing person have that additional burden, but the person in sub B who is ODing does not?
Could you please repeat that question?
Sure. The person in sub A, the Good Samaritan, also has to demonstrate, to get immunity, that the evidence for the charge of possession of a controlled substance was gained as the result of the seeking of medical assistance. But the person in sub B presumably would not.
Never applies.
I think there's a clear reason for that. You can imagine a situation where police execute a warrant on a house associated with drug distribution, although the individual who may be sharing drugs or doing drugs that has no otherwise connection to that house and may not be implicated in the larger, more extensive crime of intent to distribute could be overdosing.
Interesting.
Can I ask a question about subsection B? Or actually, maybe it's about the facts of this case. I thought the drugs with which he was, that formed the basis of the charge of possession here, were found during an inventory search. Is that correct or incorrect?
This judge said that it was in the statement of facts in the police report submitted, but in the facts that came out during the motion to dismiss hearing, it seemed clear that the drugs themselves were found as a result of an inventory search and were within the center
Is
console.
there an evidentiary hearing, or those are representations by counsel or something?
Representations by counsel.
The police report says, and this is at Record Appendix, page 7, as I was checking the doors, I looked in the windows, and on the passenger seat I observed empty clear-cut baggies with white residue powder in it. Next to it was a glass crack pipe that was burnt on the tip. Observing this, I believe the defendant was having an overdose.
I agree with those facts. However,
That's what we're bound by on a
I agree with you,
on a
Judge.
de Benedetto motion.
Absolutely. But I believe that the drugs with which he was ultimately charged were not, though, the possession of the crack pipe or the residue. I believe they were the drugs. There just happens to be 2 packages of drugs within that center console found during the inventory
Interestingly,
search.
he was charged with, I think he was charged with both. He was charged with possession of a
Yes.
Class A and possession of a
It
Class B.
corresponds very accurately.
Okay, but Part B does say that your client would be entitled to immunity if the evidence for the charge of possession of a controlled substance was gained as a result of the overdose and the
Yes.
need for medical assistance.
Yes.
And the officer says in the police report that he had gone over, the guy was slumped over, he saw him drooling, he's knocking on the window, all before, which is to say, he's overdosing and has a need for medical assistance before he sees the drugs.
I agree with that.
Okay.
I believe that, as I spoke with Judge Neyman, I would extend that to suggest that that vehicle wouldn't have been there at all had it not been for the drug overdose.
So let me ask you this hypothetical and see what your position is. And again, we look at the clear and unambiguous language of the statute, so long as it doesn't result in absurd or illogical
Yes, Judge.
result. So the cop's on routine patrol, sees a slumped over person, doesn't know, is he sleeping? Is he overdosing? Is he something? Opens the door, gives him a spray, good old spray of Narcan, and lo and behold, there's drugs all in the open center console. Does the overdosed, now no longer overdosing individual get immunity?
Well, yes, I believe they would, Judge. So,
Because the language says, or the person experiencing it who calls, right, basically, who seeks medical assistance, or is the subject of such a good faith request for medical assistance. Nobody in my scenario requested medical assistance. The police officer's doing his community caretaking role, sees somebody over on the side of the road, says, geez, the engine's going, person looks like they're asleep at the wheel, let me go over and check this out. There's no seeking of request for medical assistance.
I understand, Judge.
So how does that person get immunity?
I think that that's a good question, and the answer is that if we're dealing with alcohol and marijuana, maybe somebody has a bad night. But when we're dealing with an opiate overdose, it would be gross dereliction of duty on behalf of a police officer, as we have in this case, not to request further medical assistance.
But they did request medical
And they
assistance
did.
in your
And
case.
they
You don't
did.
have to win.
No, but
But
we're
as a
talking about
hypothetical.
absurd or illogical
Oh, I see.
results. So the hypo first one, there's no request for medical assistance because a spray of Narcan, the person is alert, and they get arrested for the drugs that are in the car. The second hypothetical, which is the police officer does not have Narcan on them, taps the window, the person's still slumped over, so they're not sleeping, and calls a fire department because this person is in need of some medical assistance that they can't render themselves because they don't have Narcan today. Fire department comes, provides Narcan, police officer sees the drugs, that person gets immunity, correct?
Yes.
But the first one, you're saying,
Well,
even though
according-
there's no seeking of medical, so the illogical result that I see is that it's just a matter of who the caller is. It's not about a police officer or whatever. It's like, hey, the police officer's doing his or her job and has Narcan, then there's no immunity here because there's no person that seeks such medical assistance.
one must give meaning to the word seek in that statute. One must. And I agree with you, Judge. However, if we're dealing with marijuana or alcohol, perhaps a police officer could render some form of aid that wouldn't require seeking further assistance. However, if seeking assistance may not be a phone call or a radio call, it may be driving someone to the hospital. Having said that, if somebody is experiencing, if a police officer, with the knowledge a police officer has in carrying out their community caretaking function, would understand the events unfolding in front of him to be a legitimate opioid overdose, it would be overwhelmingly gross negligence on the part of that police officer not to seek further assistance.
No, my hypothetical doesn't have that one. So that's where I have the concern about the illogical results.
Do we know anything about the protocol for the use of Narcan by police? Is there anything in the record in this case about that, or whether it has to be accompanied by a call to emergency medical services or otherwise, or whether you can just let the person go after giving them Narcan? Is there anything in the record about any of that?
I see nothing in the law that suggests us otherwise or guides us in that respect.
But do you see anything in the record here about Narcan at all, or how it works, or when you call someone, or?
No. Well, the police officer administered, the police officer's fellow officer arrived and had some, the police officer at first didn't have any Narcan. Mr. Ramsey doesn't have any Narcan. Upon arrival of a radio call where his partner shows up, he has Narcan. Officer Ramsey uses that Narcan and administers it. Shortly afterwards, the Pembroke Police Department show up, fire department, and administer 2 further doses of Narcan.
Do they take him to the hospital?
Yes, they do. If it pleases the court, that's my argument. Thank you.
Interesting case.
It is a very interesting case. Thank you very much. Excellent arguments by both of you. Really interesting case. And it is submitted. Want to take a break?
Keep going.
Keep going. All right. We are going to continue with our final 2 arguments. The next one is number 22-511. This is John Doe, number 1483 versus Sex Offender Registry Board. As the title indicates, this is an impounded case, so I remind counsel to refrain from using the actual name of the appellant here. And we will hear first from you, Attorney Nehring.
May it please the court, my name is Ilse Nehring, and I represent Doe. Sorb is correct. 1 month after this brief was filed, the Supreme Judicial Court issued a case, Doe number 6729. It is cited in their brief. This decision renders Doe's argument about compulsive behavior. It resolves the issue. The justices determined that the compulsive behavior prong of statutory risk factor 2 is satisfied by the last sentence of regulatory factor 2, to wit, more weight shall be given to offenders who commit subsequent acts of misconduct or sex offenses after having been convicted of a sex offense. And the implication is that argument has to be excised from the brief.
So you're saying that it's not just offenses, misconduct alone can be used for the compulsiveness factor now?
That's what the,
okay.
That's what the regulation says.
Okay.
Thank you. We appreciate your candor. You just added some time so we don't have to answer those questions. Thank you very much. It's much appreciated. Thank you.
Well, I'm not finished, but also too.
Of course not.
No, you
I hope you're not
We
finished.
realize there's meat on this bone, so go ahead.
Well, also too, I just wanted to say that even the week this case was filed, there was a very important decision in this case, Court 22188 at 101 Mass Appeals Court, which also sets forth the standard of review where an offender is claiming his substantial rights were prejudiced by the unlawful application of a factor and a roadmap on how to make a coherent argument.
Could you give that cite again, please?
Yeah, it's 101 Mass Appeals Court, 797-2022.
Yep.
It's a wonderful decision, actually.
Thank you.
So the playing field has changed a lot. And assuming I have a short argument for today, assuming arguendo, that even if the hearing examiner appropriately determined that hearsay was reliable and appropriately determined that sex offenses of open and gross lewd and lascivious behavior were committed, nevertheless, the level 2 moderate risk classification is unsupported by substantial evidence because the 3 determinations are unsupported.
Substantial evidence of clear and convincing evidence? I can never tell what it has to be clear and convincing evidence, and the burden remains on the Commonwealth, even though your client is petitioning for reclassification, right?
Yes, Your Honor.
Okay, so when we say substantial evidence, is it substantial evidence that can support a finding of clear and convincing evidence?
So substantial evidence is defined as evidence that a reasonable mind would conclude is sufficient to support a conclusion is actually what 30A section 1.6 says. But thereafter, there are 2 distinctions. It has to be substantial evidence to support a fact. A fact is established by a preponderance of the evidence in a SORP case. Thereafter, once the examiner establishes the facts to which he's applying the factors, the examiner then has 3 determinations of risk, danger, and internet dissemination or not dissemination. And that has to be established by a clear and convincing substantial evidence as well. So I believe that you need substantial evidence to make a finding of fact. And you also, what a reasonable mind would conclude is evidence. And then, again, all those facts to which were ascertained by a preponderance then have to all be put together to establish by clear and convincing evidence in the mind for the examiner, and that escapes me the standard for the words. Sorry.
So I'm sorry, Judge.
No, please.
So we're no longer looking at factor 2. Right now, we need to drill down on factors 7, 13, and 29. Is that correct?
Yes, Your Honor.
Okay, so I think factor 29 is perhaps not as strong as 7 and 13 in this case. My understanding of your argument, this is offense-free time, is that the judge found that Doe had 15 years of offense-free time, and that's incorrect because a correct calculation would show that he had 19 years of offense-free time, correct?
Yes.
But yet, the hearing examiner gave full weight to this mitigating factor. Where's the prejudice?
The prejudice is that the research was submitted in this case, and that when you've got 15 and some months, you're getting close to desistance, but the next threshold is another 5-year gap, up to 20. And then by 20, you've really reached desistance, and this person had 19 years and 9 months, something like that. So he's so close to desistance by a few months.
But let me interrupt for a moment. Separate and apart from what the research tells us about the risk to reoffend after a certain amount of time in the community that is offense-free, the most the hearing examiner can give on the positive side of the equation, right, is maximum weight.
Mm-hmm.
So whether it's 50 years of offense-free behavior versus 20, even if that's wrong, the most when the hearing examiner is doing his or her analysis is to give that person the maximum weight for that factor, correct? There's nothing more than that can be given.
Oh, okay, well,
So the question of prejudice, to me, is a difficult one because they already gave Doe maximum and full weight for mitigation. And then it doesn't the scale doesn't go any further than that. Scale just kind of stops there.
Well, this examiner tells us that he had 14 years and some months. And the other thing is that...
So that's wrong, but if the hearing examiner was absolutely correct and said 19 years, 9 months, 10 months, whatever, the most that the hearing examiner could give is maximum weight for this mitigating factor.
Right, when it's, you know, as the court suggested, 20 to 50 years, it's all the same, but there is a difference between 15 and 20, and the factors don't really give us any kind of footnotes about, well, how does this apply? What is it full weight at 15 years? What is it full weight at 20 years? What is it? So we don't really know what full weight is, and there's also a requirement that these decisions have to be a reasoned analysis that we can understand, and actually that we're guessing about what does 4.9 years mean, and is it relevant, means that this wasn't a reasoned analysis because the decision itself isn't answering the question for us, and it actually should. What did the full weight mean at 14 point whatever years, but he didn't even talk about 19.9, so that's off the table.
I find it ambiguous for what it's worth. He was then convicted of another sex offense in 2005 and has now accrued 15 years offense-free time in the community. This is the hearing examiner. I give full weight to this mitigating factor, but I find that ambiguous. If it were 20 years and he gave full weight, would it be something different than full weight at 15 years? I don't know the answer to that. I mean, I find it ambiguous. I mean, that may be helpful to you, but that's how I find it.
It's not a reasoned analysis. Are there?
No, how about on factor 7? Attorney Chennai says that the, let's call it the acquaintance issue, was not raised before the hearing examiner or judge and thus waived. How do you address that?
That's true. But however, you know, nevertheless, an examiner does have to apply the factors as they are written, and they can also apply the evidence to the facts. And I also believe that 38 decisions can also be reviewed de novo if the court believes that that's a proper standard.
Thank you.
So the factor 13, does that get subsumed into the factor 2 as far as a compulsive behavior in the decision in 6729?
No, because I believe factor 13 is violations of parole. And in this case, the examiner said that Doe violated his parole in 1998 by committing a sex offense, which it's not a sex offense. It wasn't a statutory sex offense. A statutory sex offense is a conviction for an enumerated criminal offense. He got a parole violation because he was arrested and charged with, ultimately convicted for a misdemeanor. It's not a sex offense, and I think that words matter. And when you say a person has been convicted of a statutory sex offense that entails a lifelong registration requirement in some cases, or a minimum of 20 years, that is a more serious parole violation than a misdemeanor. And these factors are basically supposed to determine antisocial behavior and the dangerousness of the person. And when the misconduct is less severe, then, the antisocial aspects or the dangerousness of the person are also less severe. So that's, anyhow, the examiner is required to apply the factors according to their terms, and this person didn't commit a sex offense. And
so the sex offender registry board, factor 13, and correct me if I'm wrong, is sexual misconduct while on supervision.
Right,
It's not a standard of whether it met a parole violation or a probation violation. And so you disagree that there was sexual, not conviction, but sexual misconduct.
Well, first of all, was the hearsay reliable? Is anonymous hearsay reliable in that application for complaint, that unnamed citizens saw a suspect who's also unnamed publicly masturbating? Is that sufficiently reliable hearsay to determine the facts by a preponderance of the evidence? There is case law that says anonymous hearsay is per se unreliable. So we do know that he was convicted of a misdemeanor, but there's hearsay attached with it that is per se unreliable. So was the underlying circumstance of public masturbation of this particular doe proven by a preponderance of the evidence? So was that, the finding of a sex offense is definitely not supported, but then was the hearsay reliable? Was it proved by a preponderance of the evidence that it was sexual misconduct? It could have been urinating in public for all we know, once everything was settled.
That's not what was in the application for complaint, or the complaint, but...
It was anonymous hearsay of citizens.
Agreed. To go back a second, let's go back to Judge Walsh's question. Assume for the sake of argument that the hearsay was reliable. Mm-hmm. Right, and this is purely a hypothetical. I understand, we understand your concerns with the hearsay. If the hearsay was reliable, would the conduct he was alleged to have done, the public masturbation, would that constitute engaging in sexual misconduct within the meaning of Factor 13? I understand it's not a sex offense, I understand your argument. Would it constitute engaging in sexual misconduct?
Right. It's interesting, the regulations say sexual misconduct 22 times, but don't define what sexual misconduct is. But I have gone to Webster's International Dictionary and thoroughly researched this, and yes, I do believe that public masturbation would be commonly understood as sexual misconduct. I admit that.
And so your concern is twofold. Number one, it's not reliable hearsay, and number two, because the hearing examiner characterized it as a sex offense instead of sexual misconduct, he may have applied an improper, we don't know how much value, proper value was attributed to it, right?
Again, not a reasoned analysis. We can't really understand. Yeah, because an abuse of discretion in these cases has been described in case law as, a decision has to be reasoned. So it's not only the LL versus Commonwealth footnote 29 outside the range of reasonable alternatives, but it's also, the analysis has to be reasoned. I see my time is up, so if there are no further questions.
Your time is up. As always, excellent argument. Thank you very much for your assistance with the case, and we will hear now from Attorney Chennai.
Thank you.
If it pleases the court, David Chennai for the board. Of course, the board's position is that the classification in this matter was properly made based on the evidence that was presented to the hearing examiner. It was based on substantial evidence. Unless there's specific questions.
I do have specific questions,
as
you might imagine.
I spent 2 weeks figuring out what questions you were going to ask.
Well, I'm not going to ask you today what percentage likelihood he is to recidivate, though if you could come up with some numbers, as you know, that would, in my view, be helpful to us and the law. What crime, the defendant is said to be a moderate risk of reoffense.
Correct.
What crime? If he reoffends, what's he going to do according to the hearing examiner?
Well, according to the hearing examiner, there's a broad range of things he might do, including anything from using a weapon and raping a stranger woman to...
I don't actually see anything in the hearing examiner's report about what crime he'll do.
I think when you read the reasons for internet, well, you got to look at the decision as a whole. The hearing examiner talks about diverse offending behaviors. talks about that he's used a weapon in the past, that he's had penile penetration of a victim.
Okay,
He
so
also-
let's start with rape, which is his index offense and which is quite a terrible crime that he committed. He committed that 45 years ago and has had no contact offenses since then. How can there be clear and convincing evidence that he's a moderate risk to reoffend in that way?
If that were his only offense?
No, it's not.
I know
I'm
that.
asking about reoffending in that way, with that crime.
What I'm saying is if you read DO 496501, it specifically says to determine the harm an individual may cause, you have to look at their past sex offending behavior, which the hearing examiner has done. The hearing examiner also took into account that there has been an excessive amount of years of offense-free time and credited him for that. Well, I think what was concerning to the hearing examiner, and the hearing examiner said it throughout the decision, was from 1998, from that offense, you get to 1998, and then 2004 and 2006, his sex offending behavior was escalating to the point where he went from, in 2004, sitting on a public bench twice, eyeing the same woman and masturbating through his pants, to actually exposing himself and masturbating in a public place. So you see an escalation.
None of that comes anywhere close to rape, which he did commit
Correct.
46 years ago. I just have a very hard time seeing how there's clear and convincing evidence that there's a moderate risk he's going to rape someone when he hasn't done any contact offense in 46 years.
But you have to look at the whole record.
Okay, so now let's look at the rest of the record.
I mean, the decision of the hearing examiner, you point to the red flags, the fact that having been convicted of that rape did not prevent him to continue to misbehave sexually.
Yes, masturbating in public.
But also you got the three other events where he's escalating in his
Well, you mean
sexual
the
behavior.
drug
No,
offenses?
the 2004 masturbating in 2006, each one is significantly different and escalating in behavior. You also have the fact that even community supervision in the past has not prevented him from committing acts of sexual misconduct.
There may be, although I'm not sure, clear and convincing evidence that he's a moderate risk to masturbate in public again. That can't support, without the additional factor that you cite in your brief, of course, because your briefs are always excellent, and so you say that this is a case in which he put his victims in fear of bodily harm by reason of a contact sex offense, which is the test, because otherwise you can't get to moderate dangerousness with a risk of masturbation in public, right?
Right.
But the hearing examiner doesn't make any finding of fact about that. Do you agree with that?
I agree with that. but
So
I
doesn't
think,
this have to be sent back so that we can find out, frankly, what they think he's moderately likely to do, and whether, in fact, that represents a moderate degree of dangerousness? Obviously, if he's likely to rape someone again, then that is quite clearly dangerous. But it's been 46 years and no contact offenses, and so you have, right, it's clear and convincing. I don't know how you get from low risk of reoffense is a risk of reoffense, right? It's just a low one. You get to moderate for something 46 years ago. And maybe he put the people in fear of a contact offense, but the hearing examiner didn't say that.
correct. But at the same time, I think the evidence stands for itself. His behaviors were escalating, and the hearing examiner mentioned that numerous times, that his sex offending behavior had escalated and was not deterred either by prior convictions or by probationary or
But the
community
SJC
supervision.
has told us it can't be deemed moderately dangerous unless it puts the victim in fear of a contact offense. And we've seen cases, I think you and I have discussed them at argument, we've seen cases where stalkers approach someone's house, or, you know what I mean, do things that are very reasonably held to amount to putting someone in fear of a contact offense.
In fact, I
But,
think we
and
had-
maybe there's something here that does, but it hasn't been found.
Correct. Again, the hearing examiner looked at this case and felt the evidence proved by clear and convincing evidence that this individual was still at least a level 2. She reduced the level 3 to a level 2. And the reason being that time has passed since that rape charge. If this was 10 years after the rape charge, he would have been a 3. She took into account that that much time has passed since the actual rape charge, since his last, since he was released from incarceration for that rape charge. So taking that into account, she gave full credit for offense-free time in the community. She gave full credit for the fact that he has aged since then and that he has established stability in the community, and found that that lowered the level 3 to a level 2. That was the hearing examiner's position in that matter. Now, if this court disagrees with that, obviously the thing to do is to vacate that. I think the issue is whether or not the evidence as it stands can prove by clear and convincing evidence that this individual was a moderate risk and a moderate danger at this reclassification. And again, it's within your purview to decide that issue. Now,
That's a purely legal question?
What?
Is that a purely legal question?
What?
Whether it's clear and convincing evidence?
It's clearly a legal issue.
Okay.
I mean, if the court decides that there wasn't clear and convincing evidence to support a hearing examiner's decision, then the court obviously should send that case back, either for remand or for to have it a new hearing. I think in this case, and this is where having the every 3-year reclassification does play a part. If you remand it for the hearing examiner to make an amended decision, then the hearing examiner will write that decision and will start the Superior Court process all over again, and this individual's 3 years are still tolling. If the case is vacated and sent back for a new hearing or dismissed outright, then he would be eligible, I believe, in December to file for a reclassification.
This was 3 years ago that this
Pretty
was
much, yes. And that's, unfortunately, these cases sometimes get bogged down, and the 3-year reclassification rule, I have to say, sometimes I feel like I'm on a hamster wheel. I start with the case, I go through the hearing, I go through Superior Court, I go through the appeals court, and I'm back having another hearing with the same individual. In fact, I've had one individual I'm on my 4th hearing with. We actually know each other by name now. So it's
Let me just ask as a practical concern, because I appreciate your guidance as far as worst case scenario for this John Doe would be a remand, because it would toll still his reclassification, which he's due.
I would say remand for the hearing
For
examiner
the
to
hearing
make an
examiner
amended.
to provide
Yeah.
right. So that's the worst thing for John Doe in the universe of decisions. If we need more clarification, because his time for reclassification will be overlapped. Just how long have you been working for the Sex Offender Registry Board for?
I started as a contract attorney in 2005 and was hired in 2007. I handle all of the Western Mass cases on the procedural level, and then I handle the majority of the appeals cases.
So just for my own understanding, does a hearing examiner ever really go from a 3 to a 1?
I have seen it. I've seen it where,
I mean,
where
I've seen
the
the Red
individual...
Sox win too, but it doesn't
Yeah.
happen very often lately. So to me, I'm looking at the scale, right? And we're looking at the standard of clear and convincing evidence and whether it's substantial evidence. But it seems to me as if they went from a 3 to a 2, given pretty horrific record index and then behavior that was escalating, despite a significant period of time in the community and all the rest. But is the more general approach a 3 to a 2 to a 1?
I can't say that's generally what happens. It's more common, but I have seen 3s go to 1s. I had a case where an individual committed his sex offenses 30 years prior, had built a new life, had basically been in no trouble whatsoever. He was reduced from a 3 to a 1, which at the time surprised me. I have seen another individual whose health issues and age pushed him back to a 1. There's many factors that might play into it, so it's not uncommon for 3 to go to a 1. Generally, it goes 3 to 2 because most people now, they're filing every 3 years, and they haven't really they haven't really made significant gains in where they need to be to reduce it to a 1 because.
And I appreciate your candor on this. So that's where I have the difficulty with, we admit, right, that there was an error. We all agree that there was an error as far as 15 years or 19 years. Right. Okay. But if the maximum kind of mitigating credit is given, does it matter? So in the analysis of the hearing examiner, so 15 versus 19, it would have been maximum, mitigating factor, right?
Right.
Would the analysis be any different if the error was, the hearing examiner said 15, but it was really 50? Would it still be maximum mitigating credit given?
I think what you have to think about is, I think a hearing examiner, and again, I've had this experience where an individual has not committed a sex offense in 30 years, where they say he's a 1, and I've seen them actually relieve them, depending on what they've done in between. In this case, you got a little different scenario, because even though technically he was released in 2001, and that's when his offense-free time went forward, he still committed criminal acts, and he still committed the 2004, 2006 sex offenses. And the hearing examiner is taking that into account, at least when granting full mitigating weight. I don't think you can say, because it's 15 and 19 in this case, that it's a situation where losing 4 years somehow reduced the weight that was given. I will say the more years with nothing in between gives the offender much more credit with the hearing examiner.
But for that one factor, I understand at the end of the day, they look at all the factors. So factor 2, the 13, now not 2, but 13, 29, 7, they look at everything. But does full mitigating weight mean something different in every single case when it comes to this particular factor, offense-free time?
Full mitigating weight means just what it says, but I do know that if you...
But does it, right? So if you're 50 years offense-free or 20 years offense-free, you get the same amount of full mitigating weight. Everything else is the same. We've got one person who's being classified who has all the same factors than the second person. One person has 20 years, full mitigating weight. One person has 50 years, full mitigating weight. Does a 50-year person get a different classification level than the 20-year person?
In my experience, if it's a clean...
Everything's the same on my
examples. Experience is the person who has 50 years gets a different classification level overall when the hearing examiner puts it all together. I've never seen a hearing examiner, and I've seen hearing examiners say, I give full weight to this, and then in the discussion, discuss how many years it was and the impact that had on the decision. If someone's been offense-free for 50 years, I think the hearing examiner in that case would give that more weight than someone who's been, say, 15 years. That's just the way the factor would work. I think the difference here is this individual was still having issues even in the 19 years that he was technically offense-free.
Your time has expired. I have one more question for you, though it's procedural. If we were to find this inadequate in some way, are we empowered to vacate and order a new hearing so that it doesn't? And would that new hearing be exactly like a new hearing? That is, there'd be no hangover from whatever it was, 2020 or whenever this was done. It would just be a blank slate, same as if they were having a new petition.
What would happen is that the hearing examiner would be ordered by the board to conduct a new hearing. Both parties would be allowed to introduce additional information that, since the last hearing, they would get to have an actual hearing where they can bring in witnesses and testify. And then the hearing examiner would make a decision. Again, in this situation, he would have 3 more years of offense-free time. He would have
So it's a de novo reclassification hearing?
Excuse me?
It's a de novo reclassification
It's a de novo,
hearing?
and the board has to approve.
Does it differ in any way from the triennial new one?
No,
That is, you say you have to show change and so on. Is that the same standard as would apply in a brand-new hearing that's a triennial new petition?
It's the same exact hearing.
Same exact hearing. All right, thank you both very much.
Thank you.
Both of your expertise is extremely helpful to us, and thank you both for really excellent arguments. Very, very helpful to us, and it's great to have such knowledgeable counsel before us. That case is submitted. See how pausing? You see the pauses I'm making between the cases.
Jeopardy music to play.
Exactly. Our final case for this morning is, I'm sure this I'm mispronouncing, but I'll give it a go, XARRAS versus J. Whitney Development, Inc., number 22-1116. And unless I'm mistaken, we will hear first from Attorney Newmeyer.
Good morning. This is quite an unusual case. It involves whether an individual may be personally liable for the contractual obligations of a construction corporation that he owns. I've found no other case in Massachusetts that has held that the owner is personally liable.
As you have a question by way of background first.
Sure.
What type of corporation was J. Whitney Development Incorporated?
J. Whitney was a Massachusetts corporation, incorporated.
Just a closed corporation, an S corp?
Closed corporation, yes, you could say that, yes, absolutely.
And the second thing you said, the individual is being held liable for the failure to, for the contractual obligation.
That's correct.
Is he being held liable for the contractual obligation, or is he being held liable for the violation of the contempt order? And is there a distinction?
It arises out of the corporation was ordered to do something. He was not ordered to do anything. He was never even added as a party in this case. This is one of the strangest things about it, frankly. But the order was addressed to the corporation based on a contract with the corporation. And that's the question.
I'm sorry, Attorney Newman. That begs this question for me. If a closed corporation like this one decides to dissolve solely to avoid the enforcement of a judgment against it, I'm asking you to assume that as a fact. What remedy, if any, does the other party have?
That is not the fact in this case.
I understand that, but let's assume it's a fact, and then you can answer my question. So assume that the facts are the corporation decided to dissolve to avoid the enforcement of this judgment against it. What legal remedy or equitable remedy do they have against the individual or anyone? Is there any remedy?
It would seem to me you would have a remedy to get back the assets of the corporation.
Why do they have to go through that?
Well,
you didn't declare bankruptcy. You dissolved the corporation. Under your theory, you could have done that the day after the judgment issued.
To do that, to file for bankruptcy, you'd have to allege your obligations.
This seems like a fraudulent conveyance of some kind. Who owns the assets of the dissolved corporation?
The assets of the dissolved corporation are still there.
They're there. Who owns them?
I guess the corporation still owns them.
Well, you said the corporation was dissolved. If it's not dissolved, if it can own property, then what's the use of your having dissolved it? The corporation retains its obligation under the judgment. Why wouldn't it? I mean, it has other obligations to its creditors, I guess, but this is a court judgment, which I would put somewhere above most creditors. Maybe federal taxes or something are above that, I don't know.
They certainly are. There is no reason why the judgment can't be used to proceed against the corporation.
Why do they have to? They have a judgment against it already. How can you create a second step, now go after the assets, by dissolving it? I don't see how. I mean, I think the court, in its equitable powers, I guess if it needed to, could call the dissolution void. All you do to dissolve it is you file a form with the Secretary of State. The Secretary of State doesn't look to see if there are outstanding judgments, creditors who aren't being paid, and so on. And you say the corporation still exists.
This corporation does exist.
All right, fine. And it is in contempt.
And it has substantial assets. That's correct.
Okay,
So
why
the
don't you
question is,
use them and put the sewer line down like you've been ordered to? Why does he have to go and find your assets? You have them, not you personally. The corporation has them. So why don't you, to the extent you still exist, why don't you undertake your obligation and put down the sewer line that you've been ordered to put down? And if the assets are so great that they can cover the cost of that, I suppose you could hire people to come and do it. It's, you know, I just don't understand. It just seems like treating the law as a game, and it's not a game.
Well, I think the best inference that can be drawn from this record is that my client, Mr. Whitney, would like to be in the construction business. And with this person, he's been in litigation in 2006.
Well, if he would complete his obligations under the judgment, the litigation would end. Instead, as president of the corporation, he has not instructed the corporation to put down the sewer lines that he's been ordered to put down, and indeed he's in some act of what seems almost like fraud to me, has decided to dissolve the corporation.
There's absolutely no
But
evidence
you've
of
just
fraud
said
what has
that he wants to be in the construction business, not the litigation business.
think that's
And
a
yet
reasonable-
he has a judgment against him. So until it's satisfied, I guess he's in the litigation business, right?
He spent years trying to comply with this. If you want to build a
And
sewer
yet
line,
he hasn't.
you have state law, you've got federal law, you've got to comply with it. There are guidelines, there are time limits when the government is supposed to act.
Did you seek to modify the judgment, or you just didn't perform it? I mean, the other side did have to get this, whatever it is, MEPA thing or what, but they've gotten it now. And there's some permit from MEPA or some no action necessary letter or something that they got.
Eventually
But they did. Eventually they got it. And yet the corporation has still not laid down this sewer line like they were ordered to. I assume it's because it's expensive. I don't know why else you wouldn't. If it only cost $1, you'd do it, right?
It's going to cost more than $1.
So, counsel, let me interrupt for a moment.
Sure.
Because what I'm concerned about is that regardless of whether you think the outcome was fair, unfair, right, or not right, a court in the Commonwealth entered judgment against your client, the corporation, okay?
Right.
And whether he decided to dissolve it or not, would you agree with me that an agent of the corporation can be held in contempt for failing to comply with the orders of the court?
I do not agree that in the construction business there is any precedent for holding an agent personally responsible for a breach of contract that is unknown under Massachusetts
It's
law.
not for breach of contract. It's for failure to comply with a valid judgment. It's true that arises out of a contract, but there's a judgment. You've been ordered to specifically perform something. The corporation has, I mean.
So I'm just going to read to you this quote from Milano and tell me how this is different. Although not named in an order against a corporation, a corporate agent may be held in contempt of that order if he was responsible for the acts or inaction of the corporation which constituted a violation of the court order. That's Milano 366, Mass 376. How does that not apply here?
In the construction area, we've had no such case.
Okay, but we might.
And we've had plenty of construction.
We may, but why does construction, educate me why, when I look at contempt, honestly, I don't look, okay, it's a construction case. Okay, wait a minute, it's a product liability case. I look at the court ordered something to be done. By the way, the something to be done is what your client asked for, specific performance, but we'll ignore it. I don't look at, oh, that's contract, oh, that's torts. I say, let's say take a slip and fall, okay.
We've had a ton of construction cases in the past 200 years.
So how is
Hundreds of
contempt,
construction cases.
right? How is
But
contempt let me finish my question.
Yeah, I will.
How is contempt different in construction cases than in any other area of the law?
The remedy in construction cases is civil litigation. That's what we use up till this case. We don't decide that...
We've been there and we've done that, right? There was a judgment ordered specific performance, and the contempt is a separate action. You didn't do what was ordered after trial. So we have had the civil underlying resolution. Tell me what I'm misunderstanding here.
Well, all I'm saying is this is unprecedented, that the owner is not...
He's the president.
He's the president?
Okay, so...
He's the sole owner?
That's correct.
He's a director?
So when they
Does not
failed
make it-
to act, which agent of the corporation failed to act? Don't you think the president failed to act?
The remedy is a civil remedy.
Yes, this is a civil remedy. It's contempt of court.
I can only point out that what the precedents have been with respect to contempt.
But this, I don't understand. This is not a criminal action. It's a civil action.
I understand that. I understand that. And all construction disputes, and we have hundreds of cases involving construction disputes, are civil actions. None of them suggest that an owner is responsible for what the contract says. That's why you form a corporation. If you can't form a corporation to have the benefits of a corporation.
Let's move to the second prong of this, piercing the corporate veil.
Right.
My understanding is you haven't said that this is an erroneous finding of fact. The judge found that the new corporation is simply performing the contracts of the old corporation.
Okay.
Is that true?
That is quite incorrect, Your Honor.
Okay, but you don't argue anywhere in your brief that it's...
Oh, I do.
That it's clearly erroneous?
Let me address that very clearly. The judge says, in his first paragraph, plaintiffs in December 2017 filed an amended complaint for contempt alleging that rather than install the sewer line, James A. Whitney, the principal and sole shareholder, had dissolved the Whitney development and reincorporated under a new name in order to evade Judge Davis' order.
That's incorrect because
that's
they
what-
incorporated 6 months prior.
16 months.
16 months prior to the dissolution.
That's 16 months.
Is the
and
new
it-
corporation undertaking the business that used to be the old corporations? Did you get all new contracts? Did you enter them into evidence below?
The new corporation, and by the way, the plaintiff has different entities too.
I'm not interested in that because he's not in
There's nothing wrong with
contempt.
that. But the idea that the new corporation took the assets of the old corporation and...
Is it not performing contracts that were originally made with the old corporation?
I don't think the record has any information on that, Your Honor.
Well, based on the web page, apparently, and the description of some of these projects, not old ones that were completed, ongoing projects, the judge found that it is engaged in fulfilling contracts made with the original corporation. That sounds like assets of the original corporation, right? Valuable contracts?
Well, there are assets in the original corporation, and that's addressed in the findings.
Well, why doesn't it use the assets to comply with the court order to specifically
There's been a
perform?
litigation.
I don't know what you're talking about. There's a judgment. Litigation is over.
Well, yeah, he's been in litigation with this person since 2006. There were two
Yes.
actions in 2006.
And asked for...
There was a settlement agreement. And there's been a litigation with this client all the time. He would just like to be in the construction business is the only reasonable inference you can draw. So it says he's been in this litigation for over 20 years.
We know the facts. I just have, before your time's up, Attorney Neumeier, you keep saying this is an unprecedented case. Have you ever seen a case where a corporation dissolved for the purpose of avoiding its obligations under a judgment like this?
I think that is...
The judge made a finding that this was a last-ditch effort to avoid undertaking the sewer line installation that Whitney Development had successfully put off for over 3 years. Such gamesmanship will not stand. So assume that to be the facts, those to be the facts.
Well,
have you ever seen a case where a company did something like this for the purpose of avoiding its obligations? And what was the result of any such case? It seems to me the closest case is Milano.
In the first paragraph of his decision, Judge Hodge says, plaintiffs in December 2017 filed an amended complaint for contempt, alleging that rather than install the sewer line, James S. Whitney, the principal and sole shareholder of Whitney Development, had dissolved Whitney Development and reincorporated under a new name. That's what he says.
Right.
That is completely erroneous. He did not incorporate until 16 months later.
I'm sorry to interrupt, sir, but I need an answer to my question, which is, you're saying this is unprecedented. Have you seen a case where a company dissolved, assume this to be true, for the purpose of avoiding an obligation, and if so, what were the results in that case?
I can't think of a construction case directly on
Outside
point,
of, in any context.
But it happens all the time that corporations are dissolved. And
in order to
avoid a judgment?
Well, that statement is made, but the judgment had existed, and he did not reincorporate to evade Judge Davis's order. That could not be done. He could have retired. Okay?
So you're asking us to find the judge's finding clearly erroneous?
It clearly would not be illegal.
You wouldn't eliminate the judgment by retiring.
I understand that.
And he couldn't do it a week after the judgment, and he can't do it 20 years after the judgment. He has to fulfill the judgment, right?
The corporation has to fulfill the judgment.
I agree with that. Which agent would direct it to do so? The president, do you think?
The corporation has to fulfill the
How? It has only one principle, and that's...
the remedy in civil litigation in construction cases is...
I'm sorry, also, this business where construction cases aren't part of regular corporate law is nowhere in the law. You show me a case that says corporate law doesn't apply to construction corporations.
Corporate law does apply to construction cases. And part of corporate law is that an agent is not personally liable under contract for breach of contract.
I agree, but what about for contempt? Your time has expired in any event. I don't know if there are more. I somehow doubt it.
No.
More? No? All right, thank you very much.
Thank you.
We will hear next from Attorney Wheeler.
Good morning, may it please the court. Gregory Wheeler on behalf of the plaintiffs' appellees. I've been an attorney for 16 years. Some of the issues in this case predate me being sworn in as a lawyer. In 2006, when these underlying cases were filed, I was in my third year in law school. How long this dispute has existed in the history of this dispute certainly gives credence and supports the decision that's on appeal here today, which is whether James S. Whitney is personally responsible or whether he should be held in civil contempt for the failures of his corporation. I know your honors have a good grasp on the history and some of the important dates. If I could just highlight some of those for you.
Can I interrupt?
Of course.
Do we need to pierce the corporate veil here?
I don't believe it's a corporate veil-piercing analysis, Your Honor. We're at a completely different stage of this dispute. As Your Honors have noted, we had a trial. There was the decision. The decision was clear. That decision was never appealed. The order was never fulfilled. We filed a complaint for civil contempt based on the failure to comply with that order. In the context of that contempt, we had a trial. Part of the relief we were seeking was to hold the sole president, director, officer, shareholder, and the only person who voted to dissolve his corporation personally liable for the failure of his corporation to comply with the order. The Milano case, as Your Honor cited...
We understand the facts and we understand the equities that you're arguing, but the real question is, can you tell us with great specificity under what legal theory the judge did not err here?
He did not err by applying the precedents that Your Honor has cited in the Milano case and its progeny. It's been established case law in the Commonwealth for 30, 40 years that where a corporation is in contempt, part of the broad equitable remedies that the court has is they can look to its agents and its servants to determine whether that agent or servant is responsible for the acts or inactions of the corporation in failing to comply with the order.
So Milano's your best case?
Milano's the best case. It's not the only case that's also cited in my brief and also in Judge Hodges' decision. In addition...
The appellant's argument in response to that is Milano is actually distinguishable. And the reason it's distinguishable is because if you look at the cases that are cited in Milano, after it states that legal proposition that you just read us, those cases are a far cry from this case, and they involve entirely different factual and legal scenarios. What's your response to that?
Well, based upon the facts and circumstances of this case, when you're dealing with a closed corporation with only one person making all of the decisions, and this one person has consciously made the decision to not comply with Judge Davis's order, to not install the sewer line, after representing to the court before he decided to dissolve the corporation that the sewer line would be installed, how can that person not be held responsible for the failure of his own corporation? To that point, and notably as part of the procedural record of this case, post-trial, we were in front of Judge Davis discussing the ongoing issue with the sewer line in May of 2018. And Judge Davis ordered us to meet with the DPW, submit a joint report to the court thereafter with a game plan. We did that. We submitted a joint report. In that joint report, J. Whitney Development says, I will install the first segment within 30 days. Didn't do it. In that same joint report, J. Whitney says, I will install the second and third segments after we obtain an advisory opinion from MEPA that no review is required. There was a delay in getting that review, circumstances beyond our control, but we did receive that advisory opinion. No MEPA review was required. He did not install the second or third segments within 60 days of that advisory opinion coming in. Instead, what he did, he dissolved his corporation shortly thereafter.
And I'm going to interrupt you there because we really know the facts of the case, so let's drill down on the legal issues. What's your response to the contention that an agent of a company cannot be held liable for a contractual obligation, and that is specifically what is going on here?
I don't think that is specifically what's going on here, Your Honor. This isn't a case where we're on appeal after trial. This is not a case that was appealed after Judge Davis's order, for example. And if there was any corporate veil-piercing analysis in that instance, I think that would be appropriate for the court to potentially consider. What we're dealing with is a contempt, and that's a different standard. I don't believe the 11 or 13 elements to pierce the corporate veil apply in a circumstance where there's a violation of a court order by a corporation and one person is responsible for that violation. So, Your Honor, to answer your question, I don't believe that there is a veil-piercing analysis here. I also don't believe that's part of Judge Hodges' decision, and I don't believe that's part of the case law that Judge Hodges
mentioned in Judge Hodges' decision.
I'm sorry, Your Honor?
It's mentioned in Judge Hodges' decision.
It is mentioned, yes, but the primary finding that he makes is the Milano case, and the other cases cited in his decision. They're also cited in my brief before the court.
What was ordered? What's the remedy here for the contempt?
The remedy for contempt was to hold James S. Whitney personally responsible to see that the sewer line is installed forthwith.
And there's no daily penalty or anything like that? No monetary damages for the contempt so far?
Not yet, Your Honor.
Okay.
To forecast this, depending on how Your Honors decide this on appeal, if the decision stands and Mr. Whitney still fails to perform, I have a whole host of remedies I could potentially pursue, including applying for a receiver to oversee the project and also daily penalties like Your Honor mentioned. But that was not part of the relief that Judge Hodge found. He did find that James S. Whitney is personally responsible to carry out the installation of the sewer line. So based on all the lengthy history of the dispute, it spanned 17 years, 3 Superior Court cases. We had a trial, we had a contempt trial. We're now here on appeal.
Could they have put down the first part without the MEPA no action letter?
Yes, and in fact, in the May 2018 joint report to the court, that's what they represented to the court that they would do. The first segment would be installed within 30 days. There is no contingency to the installation of the first segment. There's no MEPA requirement for the installation of the first segment. And that first segment actually runs across a state highway.
And when was that plan approved or submitted to the court, the one that said they would proceed in 30 days to put down the first?
Yes, Your Honor, that was part of the joint report that we both submitted on May 7th, 2018.
And when did the MEPA whatever it is, whatever letter finally show up?
Yeah, that arrived in early 2020, Your Honor.
Okay.
Final question from me.
Yes, Your Honor.
At page 29 of their brief, the appellants state, the Superior Court's order that Whitney personally, quote, carry out the obligations imposed on the corporation by the February 2017 order, end quote, is contrary to the long-recognized public policy of not ordering specific performance of a personal services contract. What do you have to say to that?
I, again, don't think we are talking about a personal services contract at this stage of the game. We're talking about a violation of a court order and the appropriate remedy for contempt of that order. So we're far beyond arguing about a contract and who breached or who did not breach, Your Honor.
So your argument is it's not a personal services contract, it's rather a remedy that was imposed after trial and then reinforced after a contempt judgment.
Sure, Your Honor. And you know, backtracking, the underlying case was filed to enforce a settlement agreement. And that settlement agreement resolved 2 other cases that were filed in 2006. And in that settlement agreement, J. Whitney Development agreed to put in the sewer line. Didn't do it. So of course we sued for specific performance. We tried that case. We won.
Breach of contract and specific performance.
And specific performance. And we won in both counts, Your Honor. We're far removed from that. We've been there, done that. So if Your Honors don't have any further questions, I would just rest on my brief.
I see none. Thank you very much. Thank you both for your arguments. The case is submitted. That concludes our sitting for today. I'd like to express the court's gratitude to the court staff and particularly to the court officers for their, as always, excellent assistance. And we stand in recess.
All rise. You off the record? Huh? I didn't hear that. We off?